And I might just jump in if that works for you, Kelly.
Great, let's do it.
All right, cool. Perfect. Good morning, everyone. I'm Vanessa Richardson, and this is Crime House 24/7, your home for breaking true crime news. Today, we're taking a turn from our usual format for an extended discussion on a case that has captivated the Crime House community and national headlines alike: the attempted murder trial of Dr. Gerhardt Konig, a Maui anesthesiologist accused of trying to kill his wife on a Hawaiian hiking trail on her birthday. To help unpack the legal dimensions of this case, how prosecutors are building their argument, what the evidence means, and what it reveals about trying an attempted murder case when the victim is the star witness, I'm joined today by Kelly Hyman, an attorney and legal analyst. And then we get to the pre-roll. Today on Crime House 24/7, we're unpacking the Gerhardt Konig attempted murder trial with attorney Kelly Hyman. Kelly, welcome again to the show. Tell us a little bit about your background and walk our listeners through this incredible case.
I am a TV legal analyst. You might have seen me on Court TV. I was actually on Court TV just until a few minutes ago. CNN, I've been on Fox News as well, breaking down legal issues. And today we are talking about a case, as the defendants call it, a he said, she said. And so that's kind of defendant's standpoint. Defendant has been charged with the attempted murder of his wife, and you point out that she is the star witness. Now, there's also going to be another star witness that we'll talk about as well, but she testified that it was her birthday and that her husband and her went on a hike, and according to her, her husband had a syringe and he was trying to hurt her. They got into a fight and that he was hitting her with a rock. Defendant's standpoint is something quite different. He is saying that, in fact, she was the aggressor and that they were having some marital issues because she allegedly had this affair, but he did not have the intent. Now, that's definitely going to be key in this case. Did he have the intent to kill her? Ultimately, the jury is going to decide whether or not he's guilty or not guilty in this case.
It's such a multi-layered case. I think one of the parts that's shocking most people is that Gerhardt and Ariel Konig were a high-achieving couple on paper. He's an anesthesiologist and she's a nuclear engineer. Their marriage, I guess, hit a wall in late 2024, as you mentioned, when Gerhardt discovered Ariel had been sending flirty texts to a coworker. They entered couples counseling, and this birthday trip to Oahu was supposed to be their fresh start. He even wrote her a card that morning calling her Angel Face. Could the affair be enough to make a jury sympathize with Gerhardt, even if they believe he did it?
Ultimately, they're going to weigh the evidence and what's presented to them, but the prosecution has to prove the case. And if, in fact, a jury is supposed to be fair and impartial and based on the elements, but if the prosecution, even though there might be some other factors, proves every element of the cause of action, then ultimately the jury would find him guilty. But you never know what the jury hangs their hat on of what stands out to them in a case until after the fact sometimes. Not always.
Yeah, definitely. And you mentioned also the self-defense part. At the heart of the defense's argument is this claim that this was self-defense, and as far as Gerhardt's part, that Ariel hit him first and that he simply reacted. From a legal standpoint, how does a self-defense argument hold up when one party ends up in the hospital with 10 blows to the head from this rock and the other walks away?
It goes to the idea of whether, in fact, that he had the intent. Now, according to the prosecution, that he did, in fact, that there was a syringe that was there as well, shows that it was planned, shows that it was premeditated. Defendant's argument is, or defendant's position is, in fact, that there was no syringe. There was no syringe found. Two hikers Healthcare providers did not see any syringe. So defendant's standpoint is he in fact did not go there with this pre-planned motive to do it, that she was the aggressor and that he was defending himself, that the other hikers, the healthcare providers saw him with the rock, but in fact he was defending himself, that he was not the aggressor as well. We'll have to wait and see if he's going to testify, because that could potentially be key for the jury of whether they find him believable or not, because they weigh the credibility of someone. They're the fact finders, and based on the facts, do they believe him? Do they believe her? Or do they believe the son, who supposedly is also going to testify to alleged FaceTiming after the alleged hitting happened, where, according to the prosecution, allegedly the defendant said that he was trying to kill his wife.
It will be very interesting to hear. I kind of want to hear that side. That's so fascinating. Ariel Konig is, as you mentioned also earlier, she's simultaneously the victim, the star witness, and a party in an active divorce and custody case. The defense made a point of highlighting that the outcome of this criminal trial could directly affect what she gets in the divorce, the house, full custody of the kids. How does that kind of entanglement affect her credibility as a witness?
From a defense standpoint, it goes to her motive. It helps establish their narrative, their side of the story, which, in fact, that she wanted sole custody. So the argument can be made that she was the aggressor. Also, that the fact that she allegedly transferred money from a joint account to her account to paint her in a different light, to paint a different picture of a fact that she was in fact the aggressor, that she in fact was someone who wanted sole custody of the kids, that she wanted all the financial and did in fact do this. So it ultimately will be up to the jury of whether they believe that side of the story of painting her in those lights, or painting her in a different light of the fact that she was not the aggressor, that her husband in fact was the aggressor of the situation.
And this is another thing you mentioned a little earlier as well. One of the most striking pieces of prosecution evidence is what Gerhardt allegedly said to his own son right after the attack when he FaceTimed him. And he apparently he appeared covered in blood and reportedly said, "I tried to kill Ariel, but she got away." So the defense says it was a suicidal goodbye, not a confession. How does something like that get litigated in court? And what does it take to turn a disputed phone call into reliable evidence?
It is a powerful statement. Let's unpack this, because there's so much there to unpack. So we have first to think a son who's potentially going to testify against his own father for statements of his father allegedly did. Now, if in fact the son testifies that way, that's pretty powerful. That's pretty credible, unless the defendants try and point out that the son has some kind of bias or that is doing it for a particular reason. But we have to remember, when we testify under oath. And if you lie, that is a criminal defense, as a criminal charge as well for perjury. But the prosecution will argue, or has argued, that this is a statement against interest. And so what that means from an evidentiary standpoint is that he made these statements, he being the defendant, was in fact against his own interest. And if the son testifies, that really helps substantiate the prosecution's case, because not only we have to remember that we have the wife's testimony, but also the two healthcare providers and their audio as well of them calling 911 and their rendition of what they believed happened, that the defendant was in fact trying to kill her. And then you have a son testify. That's pretty powerful, because the prosecution has to prove the case beyond a reasonable doubt. But that, as we say, help substantiate the prosecution's case. Not only the wife is saying it, but the two healthcare providers, the nurses that were there, but his own son is saying the same thing. That's a very strong case for the prosecution.
Very strong. Well, Gerhardt Konig's former boss, Dr. Jonathan Waters, gave a media interview in which he said, and I'm paraphrasing here, that it would not be hard for an anesthesiologist to commit murder because the drugs in their field are specifically designed to take a patient to the edge of death. There was also a backpack allegedly found at the scene containing medical supplies. You mentioned those as well, that maybe there were not actually syringes in there, but how does a defendant's professional access to certain tools or substances favor into a prosecution's theory of premeditation?
It goes to what he knows, it goes to his knowledge, but then also the intent as well. Now, if in fact the syringe was found, that's really strong evidence for the prosecution. But see, the syringe was never found. And so defendant's standpoint, that helps substantiate their fact that there's no syringe, there's no intent. He did not premeditate this, because that is really key. Did in fact, was this planned, or was just a way to celebrate a birthday and come together and go on a hike? Or did defendant plan this? Let's go to a remote area. I'm gonna bring these syringes. I am going to make sure that I use them and deal with the situation.
Very interesting. The DNA evidence in this case is interesting as well. As you mentioned, again, the bloody lava rock found at the scene. Lava rocks, by the way, are so sharp, and this is, it's just, for me, that was a really incredible kind of visual. It tested positive for a single female contributor on the stained side and 2 contributors on the unstained side. So the defense used cross-examination to establish that DNA can't tell you how an altercation started or who struck first. How do prosecutors use physical evidence like this when it confirms something happened, but it doesn't assign blame necessarily?
So if you can't establish it that way, then you want to use other evidence to help substantiate that. So you want to have the wife who testifies that talked about what exactly happened from her perspective as well, because you want to help corroborate that, in fact, that it wasn't just one time, it was multiple times. But the images, when you see her being carried out arm in arm with the 2 healthcare providers, the 2 nurses, and you see the blood on her, it paints a very powerful picture of what exactly she went through and the amount of blood. And I could see the jurors thinking, okay, with all that blood, was that in fact one time being hit on the head, or did that take multiple times to have all that the blood down her face and then covered all in her head? And so the jurors will also consider that as well. And then if the prosecution has someone to help substantiate that, you maybe a doctor, you don't have that much blood unless it's multiple times, then helps the prosecution's case be stronger.
Definitely. Well, you mentioned those 2 nurses. That was just very fortunate at that, the timing of this. So their names, I guess, Amanda Morris and Sarah Buxbaum, I believe. I don't know if I'm pronouncing that correctly. They were complete strangers. They happened to be starting their hike just as the attack was happening. They heard Ariel scream, saw a man hitting her with a rock, and they were able to identify Gerhardt in court. How significant, I'm just getting the pronunciation right now. Let me do that again. I'll start from the top. You mentioned those 2 healthcare providers, those 2 nurses who very fortunately were just starting their hike right when this was happening. Amanda Morris and Sarah Buxbaum, they were complete strangers. They happened to be starting their hike just as the attack was happening. They heard Ariel scream. They saw a man hitting her with a rock and were able to identify Gerhardt in court. How significant is bystander eyewitness testimony like that in an attempted murder trial?
It is very powerful. Here there are two strangers, don't know these people, come up and see this, hear her yelling for help, go and assist. And the 911 call by one of the nurses is so powerful because you're listening it in real time. This is exactly what's happening, and this is what they believed at the time. And I believe during the audio that they say that they believe that defendant was trying to kill her. That is very powerful testimony. Now, defendants will argue, well, you didn't see the beforehand of what exactly happened, because the defense is that she was the initiator of the fight, only saw a portion, right? A sliver of what exactly happened. Ultimately, the jury will make a determination on who, in fact, they believe.
That call must have been very powerful, and the police body camera footage was also shown in court, capturing Ariel bloodied and disoriented at the trailhead parking lot right after the attack. We know that visual evidence can be deeply affecting for a jury. How do prosecutors strategically deploy footage like that? And is there a risk it can backfire?
So you need someone that's going to testify, that's going to help establish the authenticity of the evidence. So whether if it's a body cam, whether the police officer, unless the defendants will say, okay, we're going to agree to the admissibility. But it paints a very powerful picture, because then you get to see what exactly the hike looked at. As someone who's an avid hiker, from the parts that I saw, it's like, wow, this is really kind of remote. Right, you're walking through the parts that I saw. I don't know if it's part of the trail, and you have bushes on both sides of you, and it's very, very remote as well. Now, it could potentially backfire if, in fact, it was not looking as remote, right? From the prosecution standpoint, that it was completely, open, that everyone could see. Then defendants would say, look, he wasn't trying to kill her. It was, a hike. Look how open it is. People walking up, you can look up, you can see everything. But the fact that it looked potentially really kind of remote and hidden helps establish the prosecution's case that, yes, this was planned, because he wanted to make sure it was a remote area where no one could see, but just happenly there were two people who was starting a hike and just happened to be there at that moment.
Gerhardt Konig's defense attorney has said his client may take the stand. You mentioned this earlier. We hope he does. What, if he does, are the strategic calculations there?
Prepare. From a defense standpoint, you can advise your client on whether or not it's a good idea to testify. But ultimately, it is that client's decision. Now, an attorney may say, you shouldn't testify because the prosecution has the burden. But defendant will say, no, I want to testify. Or just the opposite. A defense attorney said, you really, this is a Hail Mary moment for you, as we say, kind of like in football. You really need to testify. You have to tell the jury your side of the story. And defendant will say, no, I don't want to do that. Because it's also important to remember that once the defendant takes a witness stand, that opens up the prosecution to come in and ask their questions. Now, a defense attorney can prepare his client for their testimony and really work with potentially a jury consultant and have that, but they might have an idea where the prosecution is going and prepare. But in real time, you don't know. And is a defendant believable? Is a defendant credible? Is a defendant likable? And so you have to consider all those things. But when the defense say it's a he said, she said, most likely that the juror thinking, okay, well, we heard from her, why don't we hear from him? But now the defendant is innocent in the court of law till proven guilty. And if he doesn't testify, there might be some instruction by the jury that he doesn't have to testify, to make sure that the jury don't use that against him, right? It's your constitutional right. You don't have to take the witness stand because the prosecution has to bring the case. But it will be interesting in this case to see, in fact, since the defendant said it's a he said, she said, if he testifies.
Yes, very interesting. What does the road ahead look like from here? The trial is still ongoing. What key evidence or testimony could still shift this case in either direction before it goes to the jury?
The son. The son is definitely going to be potentially a star witness, and most likely the prosecution will end the case with him. From a prosecution standpoint, there's different ways that you try your case from the standpoint of a timeline. So your first witness helps substantiate the beginning of time, and then the last witness kind of the end of time. But then there's also another theory where you start really strong. You have your first witness is really, really powerful, right, for the prosecution, and then the last witness leaves their mark, long-lasting mark, powerful testimony for the prosecution. Now, sometimes because of scheduling conflicts, the prosecution might want to have their strongest witness, but for example, a police detective is going on vacation and can't testify in that time period and has to go first. That happens. But if defendants think that their son could potentially, help their case, then they could try and also elicit testimony from their case if in fact they bring a case. But most likely they'll have an opportunity if in fact the son does testify and what we hear is accurate for the prosecution.
That is incredible. That there are so many layers, and if he does testify, that's a lot of pressure for a son. That's a tough spot. I'm curious to see what happens. It'll be fascinating. Kelly, are any final thoughts before we wrap up?
When you talk about the son, you think about here the psychological effects, right?
Yeah.
You have a young kid, depending on his relationship with his father, gonna have to testify potentially against his father. Now, maybe it's some kind of deal with the prosecution that could come out, like if you're not, then we could potentially charge you after the fact with some kind of conspiracy or accessory after the fact of the charges, and maybe potentially there's some kind of plea deal. We don't know all this. We're only hypothetical of what's going to happen if the son is actually going to testify or not. But there's so many layers, to this case. And we also have to think about the young child where the wife is seeking custody and the psychological effects that here you have someone that is a father and is charged with killing allegedly your own mother. Like that effect on that, and then the owned son. It's sad that something like this happens, and no matter the outcome, the long-lasting effects on these children is saddening.
Absolutely. Kelly, thank you again so much for joining us on Crime House 24/7. This case has literally everything: a marriage in crisis, a birthday trip turned violent, a victim who survived because strangers intervened at exactly the right moment. They just happen to be healthcare workers, and a defendant whose own profession has become part of the prosecution's theory. You've helped our listeners understand not just what's happening in that Honolulu courtroom, but the legal machinery that makes a case like this so complex to try. We'll have to have you back as this one moves toward a verdict. Thank you again so much for being with us.
Great to be here.
Thank you, Kelly.
Of course.
Yes, we'll read the mid-roll breaks. Yep. We'll read these through. All right. When we come back, Kelly Hyman will continue to unpack everything we know about the Gerhardt Konig attempted murder trial. More time. When we come back, Kelly Hyman will continue to unpack everything we know about the Gerhardt Konig attempted murder trial. Still ahead, Kelly Hyman continues our conversation on the Konig case. When we come back, more on the Gerhardt Konig trial. Welcome back to Crime House 24/7. We're discussing the Gerhardt Konig attempted murder trial. Welcome back to Crime House 24/7. We're discussing the Gerhardt Konig case with attorney Kelly Hyman. Thanks again, Kelly. Yes. Yeah. Absolutely. When we come back, more on the Gerhardt Konig trial.